Does Donald Trump have absolute immunity from criminal prosecution? That is the question that the DC Circuit Court of Appeals will be holding oral arguments for today. Donald Trump obviously says that he has governmental immunity against criminal prosecution, and the government says he does not. So let's talk about why that is a really important issue and why that will have an enormous impact. Welcome to Law and Society. If you are new, please like and subscribe, and let's dive into it. So, last year, after grand jury investigation, a grand jury indicted Donald Trump in the federal court in DC of conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an official proceeding, and conspiracy to deprive us of our rights to vote under the color of law. So after that indictment went through, Judge Tanya Chutkin, who is the judge in the substantive case that Jack Smith brought against Donald Trump, issued an opinion after Donald Trump, in pretrial proceedings, moved to dismiss the case on grounds of governmental immunity. And Judge Chutkin made a ruling that denied that motion. And Donald then appealed to the DC Circuit Court of Appeals. Now, if you'll recall, Jack Smith wanted to fast track it even more, and he asked the Supreme Court, but the Supreme Court denied certiorari, presumptively because they wanted today's proceeding to go forward and see where it goes. So, during the pretrial process of the substantive case, where criminal defendants generally bring these pretrial motions, it's perfectly normal to bring these pretrial motions. And any good lawyer would bring them up. But what is not common is this interlocutory appeal in the middle of a criminal case. So some scholars have said that, the appellate court doesn't even have jurisdiction yet, because the matter is a criminal matter that hasn't even entered the trial phase yet. Generally these motions are preserved for appeal, and the appeal happens after the trial has happened. But in this case, governmental immunity is an issue that goes to the heart of the case, in the sense that if Donald Trump has governmental immunity against criminal prosecution, then this case doesn't go forward at all. So there are many arguments as to why Donald Trump does not have governmental immunity. And I've talked about them in my previous episodes, and many scholars have talked about why he doesn't have governmental immunity. But before I touch on that, I want to explain what Donald Trump will do. So now that the case will be heard by the DC Circuit Court of Appeals at 9 a.m. Eastern Time on Tuesday, January 9th, 2024, the panel will decide whether or not Donald Trump has governmental immunity. So whoever loses in that case will appeal that case. In Donald Trump's case, if he loses, he will prefer the step-by-step process of requesting an en banc, meaning the full district court, Circuit Court of Appeals panel of 9 judges to review this case. And then if he loses there, he'll take it to the Supreme Court. And this whole time, the actual substantive case of criminal conspiracy and conspiracy to defraud and all of that, that stays in place. And the date for that, which Judge Chutkin set for March 4th, stays, but so does the any sort of proceeding in the court. So, mind you, parties can file filings according to discovery schedule, but the court will not take any action. Judge Tani Chutkan will not take any action, and there will be no ruling, there will be no hearing until the immunity issue is resolved. Now, the heart of Donald Trump's argument for governmental immunity is that he was performing his official duties and it fell within the outer perimeters of his official duties to see if there was election fraud and go after election fraud. When that is not the power that is vested to the president. Article 2 of the Constitution and the 12th Amendment of the Constitution vests that power solely to Congress, the states, and electors. So, state legislatures, congressional legislatures by legislation, and electors have the right. So, uh, uh, that right of going and checking on elections and committing crimes in the you know uh, while going forward with what he considers to be his outer perimeters of his official duties, he went and committed crime after crime after crime after crime. Now, in Jack Smith's answer to Donald Trump's ask of absolute immunity, Jack Smith does a fantastic job. And in my previous episode, I've done a review of Jack Smith's answer to Donald Trump's claim of absolute immunity. I recommend that you go and watch that episode. But there's that argument of the Second Amendment, the Article 2, and then the 12th Amendment not vesting that power to the president. Then there is the idea that you cannot commit crimes and think that you're immune from it because under the impeachment judgment clause, Article 1, Section 3, Clause 7, it says that anybody who has been through the impeachment process can be held liable for prosecution. So criminal prosecution is, the Constitution says that that power is still there. It doesn't go away upon impeachment, which is Donald Trump's other argument that because he went through the impeachment process and was acquitted, he no longer can be prosecuted because of double jeopardy. First of all, double jeopardy does not apply because it's not a criminal trial, and the impeachment process is a political process and a constitutional tool to disqualify and to remove from office officers who have committed high crimes and misdemeanors. It's not a criminal indictment, and the due process provided in an impeachment doesn't is not the same as it would be in a criminal trial, and the same goes for the burden of proof and then the jury coming out in a criminal trial with a verdict. So the two processes are separate. Trump's attorneys conflate them into one. Then Donald Trump goes and says, what I was doing was within my official duties. It's not. And because Jack Smith points out very presciently that if a president is allowed to do that, the president can pretty much tell his supporters to assassinate of his opponents during a State of the Union and thereby foreclose avenue for impeachment. He could effectively go and get into giving foreign adversaries state secrets and call it diplomacy. And Jack Smith points these out, and I look forward to their argument today. I believe in my assessment that the case for Donald Trump having absolute immunity is weak. And I believe that the DC Circuit Court of Appeals will rule that Donald does not enjoy absolute immunity from criminal prosecution. And I hope they rule on it soon so that it can go through the appellate process soon, because this ruling will determine whether and when the substantive ruling, the criminal trial against Donald Trump, will go forward. So the judiciary, the Circuit Court of Appeals, and then the Supreme Court should and must take that into consideration, that this is an interlocutory appeal coming out of a criminal trial that is set for trial on March 4th, 2024. So it would be to the benefit of justice and deference to the trial court, which is the fact finding court, that they would respect and give the lower court that time deference so that the trial can proceed in a speedy manner as it was set by Judge Tanya Chutkan, because there is a public interest in a speedy trial. Donald Trump may not be invoking his public interest, his constitutional right to a jury trial and a speedy trial. He is wanting to delay his constitutional rights to a speedy trial, but the public also has a right to a speedy trial. The public interest demands a right to a speedy trial so that we may know the truth and so the justice may prevail. Donald Trump could come off acquitted in a criminal trial. And if that happens, then it works to his favor. So anybody who is innocent would want a speedy trial. And with that said, I will leave at that, and I'll tell you that I'll come out and review the oral arguments after they happen. There might be a little bit of a time lag because I'm across the world. So with that said, please like and subscribe, and I'll talk to you soon.